committee. HB 1009 would, I think, go a long way in helping to prevent child abuse in the Commonwealth of Virginia. Under the current statute, the current code says that a court, in determining the best interest of a child, shall consider a list of a number of factors. Included in those factors is very important factor 9, which includes a history of family abuse or sexual abuse. Family abuse or sexual abuse is defined in the code exactly as I've laid it out below for the purpose of this section, other abuse, and basically it's acts involving violence, force, bodily injury, threat of death, some very serious stuff. The one thing that the definition does not include under section 9 is acts that occur outside the family. In other words, if you abuse your own child, yes, that can be taken into consideration and it should. But if you abuse someone else's child, if you're a serial child molester, if you rape a woman who's not your wife, if you rape your girlfriend, if you commit sexual assault, child molestation outside of your family, it's not considered a factor when determining custody. And I think it's very important that it be considered a factor.
So,
I don't think...
Let me ask you a question.
Yeah.
You're saying if someone is on the sex offender registry for acts that occurred outside the household, that can't be considered by the court?
I'm saying that it is not required to be considered by the court, whereas these acts of abuse are required to be considered by the court. I'll have some people testify in a moment as to what happened in their individual cases when courts did not consider, for example, one case involving a man who had a girlfriend who had several protective orders against him for assault. The woman, he was the father of a child. The mother of the child was unaware of these protective orders. It was not considered by the court, and later on the man harmed his own child. And you're going to hear some testimony about that in a second.
So make sure we understand what we do before you the testimony. So everything you're putting in here, the court already can consider. You just want the court to be required to consider it.
Well, the court can consider anything. The court can consider that the man's last name begins with an L if the court wants to. Because 10 allows the court to consider anything it deems necessary and proper to its determination. If the answer is that, then there'd be no reason to have any factors, frankly, and the court could just do whatever it wants. The reason we have these factors is we require the court to consider these things because we, as a legislature, believe these things are important. The age and physical, mental condition of the child, and indeed history of abuse, we consider important. I would argue that history of abuse outside the family is important. And there's one more thing the bill does that I think is important. If you look at Section 9, it's a little different from the other sections. Section 6 of the bill says that generally we want courts to consider how close a child is with a parent. We generally want parents, moms and dads, to encourage their children to be close with their exes. Just because the parents divorced doesn't mean we don't want the children to be part of the other parent's life. However, there's an exception made in Section 9 in cases of abuse. If your child has been sexually abused by his or her parent, then you don't have to foster a relationship between your child and that parent. You understand that that parent is actually unsafe with regard to that child. I'd submit, Mr. Chairman, that if a parent is sexually molesting another child, that also suggests that you shouldn't require a woman to foster a relationship with a man who is sexually molesting children. And under the current code, you would have to, because Section 6 is required of every parent except in cases of family abuse, but not in cases of abuse outside the family. So that's another reason why I think 9 should include all acts, and these are pretty severe acts: violence, force, bodily injury, criminal sexual assault. These are some serious things.
All right, anybody here speaking in favor of the bill? Come on up. Come on up if you're speaking in favor of the bill.
Hi, I actually did not know I was going to speak for him today, but I saw his bill and was here for another purpose, and it actually fit my son's purpose.
Yeah, can you introduce yourself then?
Sorry, my name is Misty Russell, and I live in Abingdon, Virginia. My son was actually a victim of abuse. He has a diagnosis at this time of PTSD, anxiety, and depression. He has kind of overcome that and went through a lot the last 2 years with intensive counseling. And I wrote a bunch of stuff down, but just to be blunt, I've heard a lot today of different things of the intent of the court, the intent of the judge, the guardian ad litem. In the real world, that is not always what happens, and these children get lost in the system. And I think the purpose of his bill, I agree with things of having it specifically that they're held accountable to review certain things. But my son, his abuse escalated in 2012 to 2014. And I'll read some of the acts that was done to him, that he would be slapped in the face, hit in the side of the head, punched in the stomach, pulled by his hair. His dad would slap him over and over, pull him back up by his hair, slap him down. In 2011, I became aware of his dad had an assault charge against his girlfriend. 2011, he actually was investigated for a skull fracture to one of her children, a criminal investigation. At that time, I filed a protective order until that was resolved. And when I went to receive the PPO request, the judge told me that I could not piggyback, that I was just piggybacking on the abuse. And I also, as a mom, am also MSW, and if a person exhibits angry behavior, aggressive behavior, this is an indicator of what future behavior is going to be. When I first had my child, and I went to an attorney, which I'm skipping around, but I think this is important. The attorney said to me, in the state of Virginia, your child's father could be an axe murderer, and until he murders your child, it doesn't matter. So in other words, you're kind of put this instilled fear, that until your child is harmed, it doesn't matter what's going on around them. Currently, my child is protected from the abuse because it had to escalate to severe physical abuse, and he currently is not in the situation. His dad does not have legal rights or visitation after lots of counseling and lots of different things. But it could have been prevented if this law in effect would have more maybe swaying a guardian ad litem, or the different times when we tried to address it in court of this particular case, because in 2011 was a fractured skull, 2012 was assault and battery to the girlfriend, 2 other criminal CPS investigations. Abuse Alternatives would tell me that there were 3 victims that the police had to intervene, a woman out of town, just different information. And once you have that information as a parent, you can't erase it from your memory or mind that there's potential risk there. So just by seeing what he was proposing, I do feel like in my son's case that he could have avoided if it had been more consideration to this. That even though he's not abusing him specifically, or it's not on the table, but there is abusive behavior no matter who it's to, that it should be strongly considered in the case. And I do think that judges, they get into this atmosphere in the courtroom, their own little system, that it's not considered. It's always the child seems to get lost, and it's more about the parents, and it becomes more about the adults in the situation. So I think it's common sense to consider when there's abusive history here.
Let me ask you a question, and appreciate your being willing to come and share your story with us today. And I think everybody up here is parents, so can't imagine going through some of these things. And you said the abuser in your particular case was the father. When you got to the custody stage, I understand the protective order stage, the court wouldn't let you piggyback the other stuff they said. At the custody stage, did the court take testimony on these other acts of violence? The court willing to hear that? Did you try to present it? How was that handled?
Yeah. They would not allow it to be considered in the custody. They said it was 2 separate cases, 2 separate issues, because it didn't directly happen to him. Even social services, which is a whole other issue, didn't even intervene. Even though the other children were removed from the home, he wasn't removed from the home because the acts didn't.
So they allowed evidence of acts directed towards your son, but not towards others?
Yes.
Okay.
Yes.
Okay.
And we did try to address it, and I did file petitions, and even my attorney advised me until it was constant from the attorneys, guardian ad litems in the courtroom, that nothing would be done until it was actually physical something to him, which I wasn't aware that what I was expressing to you, that physical violence, I don't think had escalated to that point yet. But.
we're all a little bit frustrated with that thing you told us that the attorney told you at the front end about the axe murder thing, because that's not what we learned in our law schools, and I can't imagine a lawyer telling that to you, but we'll, sometimes we get bad lawyer bills too. Okay, thank you so much. And thank you for being willing to share all that with us. Okay, come on up and introduce yourself.
Good morning, my name is Mandy Wilson. I am a parental rights attorney. I have a lot of these domestic violence cases. I would say probably the majority of my clients are domestic violence victims who have completely lost their children because they alleged domestic violence in a custody case, and in turn they were called alienators. These parents were put on supervised visitation, and the ex launched a campaign against whoever the domestic violence victim was who was alleging the domestic violence, and called them crazy or called them an alienator or whatever else. And as a result, these people lost their children. I will say I'm also a domestic violence victim, so is my son, and I was also called an alienator, and I also lost my children for a temporary time. I do have them back. And as a result, that's how I did get into this business. I think I'm the only attorney in Virginia that sues guardian ad litem, in fact. The problem that I consistently run into in the courts, and that I personally ran into, is that the child's not allowed to testify in a custody case. I've never seen a case, even where the child is saying, so-and-so abused me, they did this. In my particular case, there was a 911 call where my son was screaming. My son was 10 at the time, and my ex was saying, right now I'm about to break your hand. They would not allow my son to testify. They will not allow the children to testify in these cases because they don't want to put the child in the middle of these custody cases between the two parents. They also will not, oftentimes, find, the judges don't want to find, I think it's 16.1-228, findings of abuse, because then they have to prosecute. I guess they're concerned that they're going to then have to criminally prosecute the parent. So I think this add-in language allows evidence of child abuse to get into some of these cases that it can't otherwise get into. So I would ask that you add the language in, because I think a lot of domestic violence, a lot of cases is not getting in, and these children in some cases are being placed with their abuser and completely taken from the domestic violence victim.
But the thing that some of us are struggling with up here is why these individual anecdotes that we're hearing, which are extraordinary events, why courts aren't finding this to be relevant information under Section 10, if nothing else.
Well, I would say I practice all across the jurisdiction. I have cases in City of Alexandria, I have cases in Chesterfield, I have cases in Hanover. I'm all over the state. I think I'm the only attorney that does tortious interference and parental rights lawsuits, so I'm also all over the state for that as well. And across the board, it doesn't matter what, we're not talking a bad judge here. I mean, 99% of these judges are good judges. We're talking they're getting bad information because they automatically assume if the wife or the husband is bringing this up in a custody case, it's because they're vindictive. I mean, that's just what judges, because they do see a lot of false abuse allegations.
So you're saying that they're hearing it, but they're just not giving it weight?
In the case of the vindictive, of the spouse saying, yeah, so-and-so did this to me, they're not giving it weight there. They're not allowing the child to testify because they don't want to bring the child into the divorce and put them in the middle. I mean, I think we heard testimony earlier, it's the worst experience one child ever experienced. So then what do you do?
But this doesn't relate to those scenarios. This relates to the person whose violence or abuse is directed at somebody else outside of the proceeding.
That's right. And
This is not spouse saying, well, he hit me, so don't let him have the kids, and the judge says, well, come on, everybody says that in the middle of these proceedings. This is spouse saying, he hit Jane Doe, don't let him have custody of the kids.
Well, what you're trying to do is show a pattern. And so look at the factors. One of the factors is substance abuse, right? And we can go back, we can look at substance abuse 5 years ago, 10 years ago, 15 years ago. It's just a factor to be considered to determine how stable is this person to be a parent, what kind of parent will they be? Well, if they've got a long substance abuse history, then we know that that parent may not be a good parent from history, or maybe they will be a good parent, but we have to look at that as a factor. Same with if we have a parent who is sexually molesting Jane Doe and Jane Smith and somebody else, that's a factor that we need to consider. And right now, the judges aren't considering. And frankly, these domestic relations dockets are crowded. You know, sometimes we're hearing full domestic cases in 30 minutes, an hour, and that's an entire parent loses their parental rights over a 30-minute hearing. So the judge is like, I don't have time. So-and-so, you've got 30 minutes, so-and-so, you've got 30 minutes, and we're gonna get it down. So if the judge, it's not listed in one of the factors, the judge may say, we don't have time, I'm not gonna hear it.
I'm skimming through, and I don't do domestic work, so I don't know these factors. Cole, which line is the drug abuse one, the substance abuse?
I don't have that. There's 11 county attorneys here.
In two, there's health and.
You're gonna, no, I mean, I know there's some generic ones about the health of the person and their mental condition of the child and that kind of stuff. Is that that's what you're talking about there?
And that's where you,
Okay, see, that's what makes it hard for me is if they are using that stuff to bootstrap in outside substance abuse, then why would they ever say outside sexual abuse of somebody else isn't admissible or isn't important? I mean, I just can't imagine a judge doing
May
that.
I address that, Mr. Chairman?
Sure.
Sure, so,
And I didn't mean to cut you off, man, I'm sorry.
Thank you. If you look at section 9, it specifically delineates which abuse shall be considered. It says, we will consider child abuse if you abuse your child. We will consider sexual assault if you sexually assault your child. And you must consider it if that happens.
Where does
If it doesn't happen,
where does it say if you assault your child?
that's what 9 currently says.
It says any history of family abuse.
Right.
Or
Family-
sexual abuse, period.
Right.
Where does it say sexual abuse of that child?
Actually, family abuse, excuse me, would be beating,
Okay.
beating your
Where,
child.
where does it say sexual abuse of that child?
Mr. Chairman, yes, the definition of 16.1228 defines, I know family abuse.
I know family abuse is defined 228, but it doesn't incorporate sexual abuse definition of 228.
It may be true that sexual abuse doesn't have to be within the family, but family abuse does, and that would include violence, force that results in bodily injury, reasonable apprehension of death, and so forth. So I stand corrected. If you cause someone to be reasonable apprehension of death outside of your child, if you viciously beat or rape, we'll leave outside sexual. You viciously beat someone outside of your family, as in the case of the first person, Mr. Russell, who talked about the man's girlfriend needing a restraining order because he broke her jaw. That's not sexual abuse, but it would not be included. I think what judges are doing is they're saying, here's the checklist we've got to consider. 1, 2, 3, 4, 5, 6, 7, 8, 9. It's not on the checklist, and I think 9 actually creates a presumption that if it's outside the family, it doesn't matter as much. Because why else did the code require it to be within the family? So, the judge can consider anything the judge wants to under 10, under the very broad necessary and proper. But I think when there's a reason we lay out these things. We could ignore all 9 factors and just have 10. Judge can consider whatever he thinks to be necessary and proper. But I think the reason we have these factors here is we want the judge to consider these factors. And I think when someone breaks their girlfriend's jaw, that's a factor that a judge should consider.
Yeah, so the question that I had asked her, that I was trying to get the answer to, was she said that judges will use history of substance abuse outside of this relationship, and they do so by bootstrapping it in under things like mental condition of the parent.
Right.
So what I'm trying to figure out is why do they consider substance abuse under that category, but not the violent assault of somebody else
Because
as relevant underlying too? Because I can't imagine a judge having that information and going, well, these 9 factors don't let me consider that. I can only do that under 10.
Mr. Chairman, violence outside the home is not the age of the parent, the physical or mental condition of the parent.
I'm not sure there's any less mental condition than substance abuse is. But
Well, I think substance abuse is a physical act and a mental condition of the parent, a physical and mental condition of the parent. If they're high all the time, that's their physical and mental condition. I think if they're violent all the time, I think many judges may say that's not their physical and mental condition. And I think that would be it. And I don't think it does any harm to include this.
did I cut you off?
no, I wanted to make sure I answered all your questions.
Did anybody else have any other questions? Thank you. I've never heard of tortious interference with What did you say, parental rights?
Parental rights, the Supreme Court recognized in 2012.
So you've been upheld, awesome.
Well, no, it wasn't me that was upheld, it was somebody else.
But the claim has been recognized and you're now able to bring it.
Yes, Virginia Supreme Court, and unfortunately, guardian ad litems do not adhere to the standards. A lot of the times, most of my clients, the guardian ad litems have never even met with them, so.
Yeah. Thank you so much. Yes, ma'am, come on up. Thank you for being here.
I'm Johanna Schukert, Chairman of the committee, members of the committee. I'm with Prevent Child Abuse Virginia, Executive Director, and I'm speaking on behalf of all of our affiliates and programs statewide in support of the amendment. One of the services that we provide through our state office is a toll-free helpline for parents and other caregivers. And over time, we've heard, unfortunately, many examples of situations where behavior of the parents outside of the family in the community, assault and battery and other forms of behavior that are patterns of behavior that may be present in the home around the child, but may not be affecting the child specifically. And we've heard of, from custodial parents who have been very concerned about the fact that their children are being mandated to spend time with a parent that is violent in other ways, and sometimes toward the child, which doesn't seem to be recognized in all cases in the court. So we have a variety of stories that have come to us over the years that make us feel that to add this language would illuminate violent behavior that could be considered. I'm not sure that it would do any damage or be negative in any way if you simply added these types of violent and traumatic behaviors that the court should also consider specifically when making these determinations. So we certainly support the intent of adding language to further illuminate those situations that the court may not be aware of or may not have considered based on the general language in definition 9. Thank you.
Mr. Chairman,
Hold on. Doug, Mr.
Mr. Chairman, question for the patron. And, I must say that a lot of people up here are very sensitive to what you're trying to do here. But I think a lot of the family lawyers are a little bit concerned that it might go too far, unintendedly. Because what you're essentially doing is writing something in that a court has to consider. Typically, in a family law case, the person who wanted to put on this evidence would attempt to put it on, and then there would be some objection on relevance grounds, and you make your proffer, and the judge makes a ruling. The judge may rule the right way, or may rule the wrong way, but at least the judge is making the decision about how far afield can you go. I remember recently I did a case where I had the gentleman in the case, I had the woman in the case. He punched out a guy at his wedding. I thought, this is great, but should he be disqualified from seeing his child? I mean, I think it's the kind of thing that a judge can consider, but it's not in and of itself dispositive about whether he can see his child. One of the worries I have is this goes so far afield that you can look at any evidence of any aggressive or abusive act that anybody's committed at any point in the past. And it can have an impact on whether that person sees their child. I mean, you talk about parental rights. I mean, potential exists that if you put on enough bad evidence about this guy, you may never see his child. And that's not, I don't think we want to get at it. We want the judges to weigh all the evidence. And that's why this factor in here that says, such other factors that the court deems necessary and proper to the determination. I mean, my question to you is, if we put an amendment in number 9 that moved or other abuse up, and it just would say, family abuse is defined in 16.1-228, comma, sexual, comma, or other abuse, and then put a period in there, then the court can look at abuse in the family context without going outside to look at everything else that this person may have done at any point in their life. Now, I don't know, I'm sorry, I wasn't here when this started, so I don't know whether you guys even got to testify, but I'd be curious to know your reaction to how this is, what additional problems this creates if we put this language in here like it is.
We haven't heard from family law folks yet. We heard from some victims of domestic abuse as well as the advocates that you've heard from.
Let me just quickly address your answer, and then the family law attorneys I know will want to be heard on this. Other abuse is defined here precisely so it doesn't go to be anything under the sun, and it's pretty severe. It is violence, not just violence, but violence that results in bodily injury, has to be bodily injury, or places one in reasonable apprehension of death, sexual assault, or bodily injury. So we're not talking about a couple of guys pushing each other around. We're talking about a serious injury here. I should note that this language is exactly the same language that's in the family abuse term defined in 16.1-228. I just copied the language. I didn't invent anything new under the sun. It's the exact same language that we use to consider, not require, to consider in a custody hearing. There's no requirement that a court, if it finds this language, has to remove custody. A court can consider, should consider, is required to consider all of these factors.
Like Delegate, the problem is, we sit here when we reappoint judges, and people come in here and they go, notwithstanding the fact that this person had a finding of family abuse, this judge gave that kid custody to that parent. And we deal with that when it's family abuse. The concern that we're having is that literally the court will have to consider any violent act to result in bodily harm. So if Delegate Lapasi punched me 20 years ago, completely outside the home, the domestic case comes up 20 years later, the court has to hear that. At that point, when the court does the reasonable thing, which is saying 20 years ago, who cares? It is nonetheless evidence in the case they had to consider. And then when that judge comes back in here, we're gonna have people line up to go, they put a child back with a physically violent person. Because there's no limitation on this that Delegate Toscano was getting to, the court, what we've done is taken away the court's ability to decide whether or not that's relevant and probative evidence, and instead it has to be admissible. Then the court can give it weight or not. But nonetheless, it's part of the case, and it's going to be held, that judge is going to be held accountable. So what you're going to end up doing is, we're going to take discretion away from judges for long ago criminal acts, because the judges are going to be terrified of not taking the kid away from that person, because they know what it's like to come back in here.
I don't think that's true, Mr. Chairman, because I think that if you look
come sit through a few of the judicial reappointment hearings, and then you'll see how they are.
Well, if you look at all these other factors, the court is not, there are 9 factors. The court certainly can, some of these factors will weigh in favor of one parent, will weigh in favor of another parent. Many of these decisions, you'll see a court say, factor 1 weighs in favor of the wife, and factor 2 weighs in favor of the husband, and factor 3 weighs in favor of this. And we don't consider a punch 20 years ago that landed a man in a hospital because it has to involve bodily injury. It can't just be a punch. We don't consider that.
Does not require someone going to the hospital.
Well, that's true, but a court would have discretion to consider these factors without including this. What we find, this is what people are testifying to, is time after time after time again, we have violent people placed with children, we have attorneys guard lives in court saying, we can't consider it. You can punch out, practically almost kill your stepchild, as long as it's not your child, your girlfriend's kid, and we're not going to consider it. And I'm trying to give more power to judges. I'm saying consider it. The judge doesn't have to accept it. But if you have a judge that allows someone to be a parent despite substance abuse, you could complain that judge allowed the parent despite substance abuse. We're just saying consider these factors.
Let me tell you, you've got a lot of lawyers up here who are shocked at the examples you're using that none of us have ever seen before, and we don't believe our judges are accepting and placing custody with people under the scenarios that you're describing. All right, would you like to?
You've heard from Misty Russell and others who described just that.
Why not?
We have others.
All right, so I'm in a precarious position in that I think our group supports the fact that this evidence should come in, and the question is, how should it come in? And we had told Delegate Levine that we support his position, but now that I'm hearing Delegate Toscano and some of our other people talking, I share some of the same concerns that you do, Delegate Toscano, in terms of the remoteness of certain acts and having to present that evidence. I think it is important that some of that information come before the court in certain circumstances, and if it's very close in time, and if it's very close in proximity, and if it's to another child, then I think it definitely should come in. Delegate LaPaz.
Can I ask her a question?
I like the way you call mine, Delegate LaPaz.
So when you, I just want to point this out because it's always good to have food for thought. But you know, as you're talking to Delegate Levine and as we're looking at this thing, you know, we ask a lot of our judges, and we want them to ultimately make some determinations. And if we are constantly codifying things and taking away their discretion about whether or not something relevant, whether or not someone should, how much time someone should serve in jail for a particular act, if we are constantly legislating away their discretion, then we're kind of taking away what our justice system does. And I think that's kind of, we try to get the best judges we can to use good discretion. I don't believe for a minute that a court would hear someone that has been brutally assaulting people in a time which would be relevant, a more recent time, and not consider that when he considers what's in the best interest of a child long term. I can't imagine use that kind of good discretion. So I think you kind of understand where I would go with this.
Absolutely, and I think you all have seen me for 6 years, and all of my group advocates for judges having discretion and being able to make those decisions. And we don't want to limit what judges can do. We trust our judges. You put our judges in place. You pick the best people that come before you. We have to trust them. If there's a problem with the judge, then that judge needs to be dealt with in a different manner. But you're right, Delegate LaPaz, they shouldn't be hamstrung by specific factors that become more and more specific to the point that we're delegating how they should rule on a particular case. It shouldn't go that far.
All right, hold on just a second. We're gonna start losing some members. We've got people on the block and civil sub. I have to be up at transportation 10 minutes ago. And so we want everyone to have their full day. We want to hear everything. We also want as many members here as possible. And so I just say that. So especially if you see people walking out, if you're in the audience, it's not they don't care about the issue. It's they just got summoned. Delegate Campbell just got summoned to criminal. They're calling his court right now. So, Delegate Minshew.
Thank you, Mr. Chairman. Mr. Chairman, I don't practice in this area. There's probably some people in the room who do. But if I'm a judge and I am adjudicating a best interest of the child case, and I see that verb shall, I'm going to hear evidence, consider evidence, and I'm going to write an order that shows that I've considered all 9 of these points, because shall means mandatory, right? So, and then I've even got that 10th kind of catch-all, that after I have touched these 9 bases with something, I'm going to put in some other, language in the order that I found to be relevant and probative. I guess my question is, if indeed a judge is doing what I just said, touching base on all 9 points, and then uses the conclusory 10th point to add on anything else, would not the universe of that cover the good point that Delegate Levine is talking about? And if not, why?
Are you saying that in the summary that judge would have said, I considered the other abuse, and either considered it in my decision or ruled against it? Is that what you're saying?
Yeah, Mr. Chairman, made that. If I'm a judge, again, I don't practice in the area, but if I'm a judge and I see that verb shall staring at me, my order is going to show that I have really considered each of these 9 points.
Well, and the shall applies to 10 as well.
Yes, it
Right.
does. As a practical matter, I don't know that all juvenile court judges put their orders, the factors in writing. They do say orally from the bench what they've considered, but it's a court not of record, so they don't always put in writing so that it's part of the record that goes with the client outside of court. But they should be doing In factor one, I consider this is what I consider factor two, and I know they do that in circuit court. So yes, it should be covered.
Okay. Anybody else here to speak? Did you get to finish or did we cut you off?
I finished, but I
Okay.
guess I can some more questions.
Delegate Miyares.
Part of my question is, under section 9, family abuse as defined under 16.1-228, which they list 6 drugs where they freeze provide healthcare, abandonment, any sexual act, whether the parents, mental or physically incapacitated, where they leave the child alone. And so what I'm a little curious about is, isn't that already under 16.1-228?
The reason it's,
And the patron can speak to this.
the reason it's not is because you'll see that that long list of factors is limited to family members. It's got to be your child. It's not that the acts are different, it's who the acts are done to that's different. And 16.1-228 limits family member and defines it as your child, your spouse. It would not include your girlfriend or your girlfriend's children. One more thing that I do think is important to point out is that section 9 is distinct from the other sections. Not only, by the way, does this not limit a court's discretion, but if we don't include it, what we're basically saying is if you alienate your child, let's say you know that the father is abusing his girlfriend's children on a regular basis, and you say to the court, Your Honor, I don't want my kid with this man, their father, who's regularly abusing his girlfriend's children. The court is required to hold that against you. The court is required under 6 to say, you're not allowed to alienate your kid from your father unless he's abusing them. If he's abusing others, you are not allowed. Factor 6 says, we're going to examine your propensity. Yeah.
I want to get your bill out of here, so I'm going to offer what I perceive to be a friendly amendment.
Okay.
Let's just see if you like it.
Okay.
If you like it, we'll see if I can get enough votes up here. If
Fair
you
enough.
don't like it, then I fear for the status of your bill.
Okay.
So here it goes. Okay, Mr. Chairman, I move that we strike lines 40 through 45, and that on 34, after the word sexual, we insert a comma and then the words or other relevant abuse, comma, and then strike the or other abuse. So that
I'm fine with that.
make the, you would still have a relevance standard that you'd have to go through, but it does interject another thing, other abuse. And it's up to the court to figure out whether the actions are abusive and relevant. And you can argue emotional distress, you can argue anything under the world. The court still has to make a relevance judgment before he or she considers it.
I fully support that.
Pardon? Of course, what do I know?
Delegate Toscano, are we gonna keep lines 40 through 45?
No, he's striking all of
Okay,
it. So he's just taking out the definition in before other abuse, he's putting the word relevant. I'm not sure how the court's gonna interpret other relevant abuse, because the term abuse then, so the question would be, for example, would stalking or a fight, or would that be abuse or not? I don't have any idea.
Mr. Chairman, the beauty about those words are, one, the court can make a judgment of one, whether it's abuse, second, if it's relevant, and if there's a stalking allegation that he or she doesn't find is relevant under 9, you still got the catch-all with 10, so he can get the evidence in that way too.
Okay? That's the amendment you meant, right, Scott? Yeah, all right, that's the amendment that was just adopted. Okay, anybody else here to speak to the bill? All right, you get the last word.
Very quick, Mr. Chairman. The point that the witness just made is essential. 6 says that if you alienate your child from the other parent, that will be used against you. 9 says you are allowed to alienate your child from the other parent when they're an abuser. If we don't include this language, then the court will say you're not allowed to keep your child from someone we know has a long history of abuse. And that's why it must be in 9, and that's why it cannot be taken into consideration in 10, and therefore is necessary. I urge adoption.
All right, thank you, sir. Delegate Lubasi.
I have a motion.
Delegate Lubasi.
Motion to lay it on the table.
All right, we have a motion laid bill on the table. Is there a second? Moved and seconded. That's not an available motion. All those in favor say aye. Aye. Those opposed?
No.
All right, the bill's laid on the table. Thank you, sir. All right, the last two bills today are delegate with posse's bills.